Article 40, Machine. Canon 1657. A machine is a device containing one or more inorganic moving parts capable of harnessing, transmitting or modifying energy. A machine may also be correctly defined as a good. Canon 1658. A valid machine is any machine whereby its make and model, including blueprints, are properly registered. It possesses a nameplate and has been tested and certified to be mechanically sound to its registered specifications. Canon 1659. As all machines are built from objects and concepts, all machines by default are held in trust in accordance with these canons and the sacred covenant Pactum de Singularis Caelum, consistent will. All objects and concepts. Canon 1660. A machine that is not properly registered with the Hokkaidan Society in accordance with these canons is an unregistered machine. Canon 1661. An unregistered machine has no rights to use or be used on or with the property of a Hokkaidan Society. Article 41, Register. Canon 1662. A register is a ledger of records into which regular entries are made of details of form regarded as sufficiently important to be exactly recorded. Hence, for anything to be regarded to be on the record is literally to be recorded into a register. Canon 1663. A valid register has a specific purpose, level of importance relative to other registers, condition of entry and conditions of transfer of certain rights in accordance to valid law or statute. When two registers are compared, the one having superior standing in law has rights over the other register. Canon 1664. The highest and supreme register of all possible registers is the Great Register of One Heaven in accordance with Pactum de Singularis Caelum. Any law claiming equal or higher standing to the Great Register of One Heaven is automatically null and void from the beginning. Article 42, Record. Canon 1665. A record is a written memorial of some form of event and actions, an account under attestation or oath as fact, and the conveyance of proof of the such fact then preserved as knowledge and authentic history of the cause within entries united by some identified within a memorandum, journal or affidavit and certificate or summary. Canon 1666. A valid record in the Great Register and Public Record of One Heaven, also known as the Great Roll of Divine Persons, also known as the Great Book of Souls, also known as the Great Book of Life, also known as the Great Record of Time, also known as the Great Book of Perfect Divine Notarial Procedure, also known as the Great Book of Divine Law, comprises of 3 actions entered into 3 spiritual books, consistent with the etymology of record from 2 Latin words re-meaning property, and cordis means heart, body, mind, thought and reason, and spirit, soul. The event as the sign is the first action, entered into a memorandum of Hokkaidan space and time as a true written memorial to the event and associated proceedings and actions, and proven by the unique existence of a 18-digit Hokkaidan space-time number, and 2. The register entry as the sacred seal is the second action, as attestation to a true summary of facts associated with the original memorandum of event and unique 18-digit Hokkaidan space-time number, and 3. The conveyance as the delivery is the third action, as proof of a valid event and account to a ledger as a true account by a certificate or letter or gazette posting, or all 3, connected to the register entry and the unique 18-digit Hokkaidan space-time number. Canon 1667. No inferior person or inferior juridic person is permitted to be ever entered as a record in the Great Register and Public Record of One Heaven, except when such an entry is recognition of reversion and recovery of all rights, title, instruments, certificates, uses, property, claims, trusts, deeds, estates, symbols, seals, powers, authorities, commissions, sacraments, funds, franchises, records, assurances, and securities from such an inferior person or inferior juridic person back to the society of one. Heaven. Canon 1668. In accord with these canons, any entry of an inferior person or inferior juridic person into the great register and public record of one heaven, is absolute acknowledgement, agreement, consent, approval and acceptance that any and all rights, title, instruments, certificates, uses, property, trusts, deeds, estates, symbols, seals, powers, authorities, commissions, sacraments, funds, franchises, records, assurances, and securities claimed, or possessed, or held by such an entity is subject first to the rules and canons of one heaven above all other law. Article 43, Value. Canon 1669. Value is a fictional form being the assignment of a degree of importance, desire, and numerical value in currency to a particular form. Hence, value is a subjective ranking of a form relative to other forms, often on simple monetary value. Canon 1670. A good is worth as much as the value at which it can reasonably be sold. Canon 1671. The most important, the rarest, and therefore the most valuable form in history is objects believed to be divinely inspired and sacred. Canon 1672. The least important, the commonest, and therefore the least valuable form is objects in matter, considered to be abundant and easily available. Canon 1673. By definition, the most valuable form of all possible forms is these canons and the sacred covenant. Pactum de singularis caelum. No object, nor form may be considered more valuable. Canon 1674. No man, woman, person, aggregate, entity or spirit may claim ownership of the sacred covenant. Pactum de singularis caelum other than the divine creator. All copies, reproductions, abstracts and extracts of the sacred covenant remain at all times the sole property of the divine creator. Article 44, Asset. Canon 1675. In a general sense, an asset is a fictional form representing other forms regarded to possess a formal unique identity and value. As such, an asset is a net store of real value. Canon 1676. In a formal sense, an asset is any sufficient effects, property, or goods of sufficient value enough to discharge any burden cast upon a trust or estate in satisfying its debts. Therefore assets do not exist without some relationship to a trust or estate. Canon 1677. Assets may be defined as either tangible or intangible. Canon 1678. A tangible asset is any asset, such as buildings, land, equipment etc. that has physical form. Canon 1679. An intangible asset is intangible personal property, acquired for money, that does not have a face value or a ready market. An intangible asset is also defined as any valuable property of a business that does not appear on the balance sheet, including intellectual property, customer lists, and goodwill. Article 45, Debt. Canon 1680. In a general sense, a debt is a fictional form representing an obligation by one or more persons, due to another one or more persons, whether it be to perform an act, or make payment of certain currency, goods, or effects. Canon 1681. In a form sense, a debt is a form possessing negative value that may only be effectively discharged, providing assets of sufficient value exist within the trust or estate to render a zero balance or remainder in the accounts. Article 46, Account. Canon 1682. An account is fictional form being a detailed memorial or record or financial summary of any distinct relation of obligation in terms of debit or credit or assets or liabilities in relation to a trust, or estate, or fund. Canon 1683. No property or asset or liability is held validly unless it is recorded into the proper account of the trust or estate or fund in accord with these canons. Article 47, Income. Canon 1684. Income is the sum of all earnings received from ownership, lease, and use of property including business, land, investments, and one's own work. Canon 1685. Under inferior Roman law, a tenant of a possessory estate has the right to gain a fair income from the land and its immovables from any leaseholders. This is called tax. Canon 1686. Income gained from possession of property to which the person is not entitled is fraud and unlawful. Canon 1687. Unless a person holds valid title to property issued by a valid Hokkaidan society, then any income received from use of property is unlawful. Article 48, Liability. Canon 1688. A liability is an obligation, debt, or responsibility owed by a person to another within the context of trust and estate law. Canon 1689. A liability does not exist if no trust or estate exists. Canon 1690. The obligation to a liability is defined by the relationship of the person to the trust or estate and the rules of agreement. A person cannot assume the liabilities of another without having a relationship to the trust or estate that holds the liability. Canon 1691. The holder of an original agreement generally accepts all liabilities of the trust or estate administered by that instrument, unless another related to the trust or estate consents to act as surety to the liability. Canon 1692. As it is the obligation of the trustee on behalf of the executor of the trust to administer all assets and liabilities, any acceptance of liability on the part of a beneficiary may only be temporary, according to some fixed term or conditions. Canon 1693. Once a beneficiary completes any obligations or agreement associated with acceptance of surety for a liability, the obligation for any continuing liability must automatically return to the executors and administrators and their trustees of the trust or estate. Canon 1694. When a person dishonors an instrument, properly formed and registered, then a deed of dishonor may be issued. When a deed of dishonor properly formed is dishonored, a deed of protest may be issued. When a person has dishonored 3 perfected instruments, they have then fully consented and accept any attached liability even if such consent and acceptance has not been made orally or in writing. Canon 1695. When a person uses any property of a trust or estate without permission, they automatically assume a relationship with that trust or estate as a beneficiary and accept full liability attached to the use of that property. Canon 1696. A person who admits mistake and error in trespass on the use of property of an estate or trust without express permission is automatically freed of any liability obligations and full liability returns to the executors or administrators and their trustees. Canon 1697. Any executor or administrator or their trustees that refuse to act within their obligations and accept when an obligation is returned upon admission of a mistake or non-consent as surety is guilty of a gross breach of duties and automatically becomes personally liable for any and all associated liabilities. Canon 1698. Any liability created in fraud automatically becomes the personal obligation of the person who committed the fraud. Article 49, Currency. Canon 1699. Currency is a formal system of money based on some standard unit of measurement, a store of value, and a medium of payment in exchange. Money is anything that is generally accepted in exchange as payment for goods according to some estimated value. Canon 1700. While the key function of money is to act as a medium of exchange, when money is formalized to be recognized as a store of value, a unit of account and method of payment according to certain rules, then it may be regarded then as currency. Canon 1701. All currencies and therefore money may be defined into two types according to the method of underwriting the value of the money, commodity and property. Canon 1702. Commodity currency is the simplest form of currency whereby the money itself is the underwriting and carrier of value. The most common examples of commodity currency are gold and silver coins, now rarely minted in favor of debased metal coins of less intrinsic value. Canon 1703. Property currency is any currency that uses rights of property by claim, lien, and other mechanisms as the method of underwriting. All property currency is based upon the rules of negotiable instruments and the associated concept of temporary trusts in which to convey the property. Canon 1704. All notes, also known as banknotes and bills, are by definition fungible negotiable instruments. Therefore property currency based upon one or more classes of property conveyed into temporary trusts is its store of value. A bank may choose to issue one banknote against one temporary trust for one trust corpus of property, or may choose to issue multiple banknotes against a temporary trust to the total value of the trust corpus. Canon 1705. The two most common forms of property used to underwrite currency as negotiable instruments are rights of claim, also known as rights of redemption, and liens, most notably maritime liens. Currency based upon redeemable value was most common in permitting the property of the instrument to be converted into a good of equivalent value, in particular gold or silver. However, most currency based on redeemable property has been withdrawn in favor of currency based on liens. Canon 1706. The principle of property currency based on liens is the acceptance by an estate that because the property under lien cannot be effectively seized, the lien holder is granted permission to monetize their right and then sell the debt to recoup their loss. Canon 1707. The significant difference between monetized maritime liens conveyed into trust and issued through the structure of property currency and negotiable instruments is that a monetized bill of exchange is not permitted to be dishonored by any merchant within the Roman system, without severe penalties. This is because maritime liens represent the highest lien coming from the authority of the highest estates, and to dishonor this authority is to dishonor the entire global Roman land, property, and finance system of the world. Canon 1708. In each estate deliberately bankrupted and forced to issue equitable title property currency through a private reserve bank, the live birth record of each newborn child is monetized as bonded promissory notes and then sold and conveyed into a separate cestuique, vi, trust per child, owned by the private reserve bank. Upon the promissory note reaching maturity and the bank being unable to seize the slave child, a maritime lien is lawfully issued to salvage the lost property and is itself monetized as currency issued in series against the cestuique, vi, trust. Thus the currency of private reserve banks is only leased by the population, who then pay rent in the form of interest for currency they underwrite because of the monetized maritime liens issued against them as Roman slaves. Canon 1709. As the Society of One Heaven is the first see and the one, true and only holy see, all currency issued under maritime liens is now the property and subject to the true see in accordance with these canons and the sacred covenant Pactum de Singularis Caelum, Canon 1710. Any treasury, or reserve bank that refuses to acknowledge that any currency issued under maritime liens is now ultimately the property of the first see and the one, true and only holy see being the Society of One Heaven is open consent and agreement that the rules guiding the global Roman financial system of currency no longer apply and are null and void. Canon 1711. Any treasury, bank, or financial institution that dishonors currency issued by a valid Hokkaidan society commits an act of extreme dishonor and by such action openly accepts full liability and underwriting of such an instrument. Failure to further honor such a valid instrument is open consent by the particular Roman institution that the rules guiding the global Roman financial system of currency no longer apply and are null and void. 2.2 Form creation and change. Article 50, Action. Canon 1712. An action or act is an event in time and dimension based on reason, involving the transmission of energy and awareness relating to form. Canon 1713. All actions or acts may be classified into four categories: general, specific, juridic and proscribed. Canon 1714. A general action or act is any act that takes place that does not involve specialized knowledge or skill that is neither proscribed, nor related to the official function or statutes of a juridic person. Canon 1715. A specific action or act is any act that takes place that involves the presumption of specialized knowledge or skill that is neither proscribed, nor related to the official function or statutes of a juridic person. Canon 1716. A juridic act or action is any act that takes place relating to the official function or statutes of a juridic person by a qualified person, including all form which essentially constitutes the act itself as well as the formalities and requirements imposed by law for the validity of the act. Canon 1717. A proscribed act or action is any act listed by statute of a juridic person as being an offense. Article 51, Ritual. Canon 1718. A ritual is any process based on custom, involving the transmission of energy and awareness relating to form. Canon 1719. Any ritual involving the simulation of human or animal sacrifice, or actual sacrifice is strictly forbidden in all its forms. Canon 1720. Any ritual contrary to the prescript of a valid canon is therefore reprobate, suppressed and not permitted to be revived. Article 52, Custom. Canon 1721. A custom is any long-established practice resting on authority by long tradition of consent to justify a ritual. Canon 1722. Whilst a custom may have a long tradition, its lawfulness is dependent upon its consistency to body of canon known as Astrum Iuris Divini Canonum in accordance with Pactum de Singularis Coelum. Canon 1723. A custom not considered lawful in accordance with these canons is therefore unlawful. A custom alone may not be assumed as an unwritten law. Canon 1724. Any custom contrary to the prescript of a valid canon is therefore reprobate, suppressed and not permitted to be revived. Article 53, Adjudication. Canon 1725. Adjudication is the action of promulgating a new form by judicial procedure. Canon 1726. A valid form is considered to be created by adjudication when such form has been orated within a valid court at least once before officials of the valid court issue a document attesting to the form, with the same effect, validly registered in a great register of a valid Hokkaidan society, and the document has been published in at least 2 communication mediums for view as a notice. Article 50.